This is the last stand for so many landscapes. I talked about that yesterday. And few endeavors today are more important than the work that Tom Linzey and Margil are doing to institute rights of nature governance in the U.S. and globally with laws and structures. I suspect that you will be very happily shocked, actually, I am, to hear from them just how far this movement has grown from being a literal outlier just 15 years ago when it might as well have been a UFO, forget being on the radar screen. As Thomas points out, the very nature of a movement is about gaining rights. Shifting from a paradigm of nature as property to nature as rights bearing is a legal game changer. It has profound repercussions for conserving landscapes and indigenous lands and cultures, and also really for democracy, actually, which is work that Tom and Mari have done for a very long time as well. Thomas and Mari have been defining the forefront and helping to define the forefront of this movement since its practical inception in Pennsylvania in 2006, which is when Thomas first spoke at Bioneers, and this work was really just beginning to break through the ground. As senior counsel now for the newly created Center for Democratic and Environmental Rights, Thomas previously co-founded the Community Environmental Legal Defense Fund and the Daniel Pennicock Democracy School. He's the author of several really excellent books, including Be the Change, How to Get What You Want in Your Community. And Mari is executive director of the Center for Democratic and Environmental Rights, and she leads its International Center for the Rights of Nature, which you'll hear a lot more about shortly. Previously, as associate director of the Community Environmental Legal Defense Fund with Thomas, she assisted the very first places in the world to secure the rights of nature in law, including in Ecuador, the world's first national constitution to do so, which was a daisy chain that actually originated here at Bioneers. This is how connections happen and things happen. Very cool. Mari works internationally, as well as with indigenous peoples and tribal nations in the U.S. to advance rights of nature legal and policy frameworks. She's the co-author of Exploring Wild Law, the Philosophy of Earth Jurisprudence, which is also really an excellent book. Bioneers ourselves are really honored to work with Tom and Mari on our own Rights of Nature initiative with tribes here in North America through our Indigeneity program, which our Indigeneity co-director, Carol Romero, will talk about very briefly following their talk right after this. So please join me in welcoming two of the most heroic lawyers. I love great lawyers, actually. A lot of them get a bad rap, but these two are on the right side of history. So Tom and Mari.
Hello, Bioneers, and thank you for that introduction, Kenny. It's our distinct pleasure to be back at Bioneers this year. It's hard for me to believe that it was all the way back in 2006 that Bioneers asked me to speak at my first conference.
Hi, everyone. It's so good to be here. It's so good to be back. As it happens, it was in 2006 in the small rural town of Tamaqua in northeastern Pennsylvania in the United States that the first rights of nature law anywhere in the world was passed. It recognized ecosystems, including the Little Schuylkill River, as having the legal right to exist and flourish.
In 2008, the people of Ecuador voted overwhelmingly to ratify a new national constitution, the first in the world, to enshrine the constitutional rights of nature, or Pachamama, into law. It recognized the legal rights of nature to exist, regenerate, evolve, and be restored.
In 2010, Bolivia adopted its Rights of Mother Earth law. And in 2016, Colombia's Constitutional Court ruled that the Atrato River possesses rights to protection, conservation, maintenance, and restoration.
In 2018, the White Earth Band of Ojibwe adopted a Rights of Nature law to protect Menomin, or wild rice, recognizing the right of the rice to pure water and freshwater habitat. The Menominee, Yurok, Ponca, and Nez Perce tribal nations have also recognized the rights of nature, recognizing the Menominee, Klamath, and Snake rivers as having rights.
In 2019, the High Court of Bangladesh declared that all rivers in the country possess rights. That same year, Uganda enacted national rights of nature protections into law. Over the past 4 years, courts in Colombia and India have recognized the Amazon, Ganges River, and other ecosystems as having rights of their own.
And on this past election day, November 2020, in the United States, voters in Orange County, Florida, home to Orlando and Walt Disney World, with over 89% of people voting yes, approved of a new law securing the rights of the Wekiva and Econlockhatchee rivers to exist, flow, be free of pollution, and maintain a healthy ecosystem.
Over the past nearly 15 years, all over the world, governments, courts, indigenous nations, and people in their communities have secured the rights of nature in law. After all of these developments, the question is no longer, can nature have rights? It can, and it does. The questions before us now are, how do we secure the rights of nature in every legal system around the world? And how do we do it while there's still nature left to save?
The movement for the rights of nature is growing, focused on transforming not only how we govern ourselves towards nature, but transforming how nature itself is treated under the law, from being without even the basic right to exist to finally being recognized as a living entity with legally enforceable rights. This movement is growing across communities, across countries, across continents, as people have grown tired of trying to make environmental laws work the way that they should work. For more than 10 years, as a public interest environmental lawyer representing communities, environmental groups, and municipal governments, I too struggled to enforce environmental laws. Laws in the United States that have been mirrored around the world, such as the Clean Air Act, the Clean Water Act, and the National Environmental Policy Act. But after a decade of struggling to protect the natural environment under these laws, the only honest conclusion I could draw was that the system was rigged, that environmental laws do not protect and were never intended to protect nature.
So here's how it works. Environmental laws establish permit systems. These systems permit or legalize industrial activities such as fracking for oil or gas, or operating large-scale hog and chicken factory farms, activities that cause known harm to people, communities, and nature. In the United States, these permitting systems authorize the release of 4 billion pounds of toxic chemicals into the air each year, and authorize the release of 80,000 synthetic industrial chemicals into the environment and into our bodies. The permits and the laws that authorize them are most often written by the very industries that these laws ostensibly regulate, and are used to protect the rights of corporations to frack, to mine, to pollute, rather than to protect the rights of communities and nature to be free from harm.
Public interest environmental lawyers spend our time arguing not over whether pollution should occur, but how much will be allowed, and not over whether toxic chemicals can be dumped into the air or water, but how much can be dumped. We are forever stuck in fights about how activities such as fracking will happen, not whether they should happen at all. Under this current system, those fighting to protect nature merely become enforcers of regulations written by extraction and other industries, regulations which legally authorize the exploitation and destruction of the natural world.
Under this system, it's no wonder that across the globe we face overlapping environmental crises. In 2019, the Intergovernmental Science Policy Platform on Biodiversity and Ecosystem Services, an organization with over 130 member countries, reported, quote, biodiversity is declining faster than at any time in human history, with a quarter of all animal and plant species now threatened with extinction. And the United Nations recently reported that there is, quote, alarming evidence that important tipping points leading to irreversible changes in major ecosystems and the planetary climate system may already have been reached or passed. Such impacts, the UN said, could, quote, transcend generations.
The question is no longer, is human-caused climate change real? It is. The question is no longer, are we now in the sixth great extinction, this time caused not by an asteroid, but by humankind? We are. Rather, the question before us now is, what are we going to do about it?
Many are answering this question by recognizing that the problems we face are systemic, that they are structural, built into the very bedrock of Western law and culture, built on the principle that nature exists to serve human beings and human beings alone. As philosopher Francis Bacon once so helpfully explained, it is Western civilization's duty to, quote, torture nature on a rack to extract her secrets.
We've created legal systems based on the idea that nature is our subordinate. To borrow a term from other movements, we have successfully othered nature. We've failed to recognize our dependence upon her, failed to recognize that we are not separate from, but part of nature. This othering of nature was necessary, of course, in order to legitimize, indeed, in order to accelerate and legalize her destruction, so that large swaths of the population wouldn't question how we treat nature.
But by elevating ourselves above her, separating and isolating ourselves from nature, by refusing to understand nature as a living entity, we bring our own ruin. And in taking ourselves down, we seem intent on taking everything else down with us.
Indigenous communities have a different worldview, recognizing nature as a living entity or as a relative. The Menominee people understand the Menominee River as their sacred place of origin. The Maori express their relationship with the Wanganui River in New Zealand as, I am the river and the river is me. While First Nations have embraced nature as something that can't be owned, the concept of merging the Western tradition of legal rights with protection of the natural environment took a long time to surface.
In 1972, that journey began with University of Southern California professor Christopher Stone, who wrote a law review article titled, Should Trees Have Standing? It advanced the notion that nature, represented by environmental groups, should be able to access the courts directly for its own protection. The article ran headfirst into a perfect storm: the Walt Disney Corporation's efforts to build a ski resort bigger than Disneyland in what is now Sequoia National Park, and the Sierra Club's lawsuit to stop it. Heard eventually by the United States Supreme Court, the case produced one of the most famous dissenting opinions in court history. Written by Justice William O. Douglas, Douglas embraced this idea, writing that protecting nature required the, quote, conferral of standing upon environmental objects to sue for their own preservation.
It took over 30 years for that concept to be realized in Western law. When the people of Tamaqua, Pennsylvania, took a stand in 2006 and passed the world's first law recognizing the rights of nature. When I helped to draft that law, I couldn't have imagined in my wildest dreams that the rights of nature would now be the law of the land in countries around the world.
At its base, this work is about acknowledging that we need to make a fundamental shift in how we govern ourselves toward nature, transforming nature from being considered other, incapable of possessing rights and protections, to nature being recognized as a living entity with legal rights, finally afforded even the most basic rights to exist, to thrive, to regenerate, to evolve, and to be restored. The right of rivers to flow, the right of species to habitat, the right of ecosystems to a healthy, stable climate. The status quo is no longer an option, and trying to make meaningful change under a legal framework that elevates humankind over the natural world, legalizing our use and exploitation of nature, is no longer an option either.
We know how fundamental social change happens. We've witnessed it throughout history. We're witnessing it today. It happens when we join together in people's movements, coming together across cultures and identity, across ethnicity and faith, across borders, joined together by a shared understanding of the harm and injustice that existing legal systems are built upon, and mobilizing together for change. What would it look like if coastal communities and nations began adopting laws recognizing the legal rights of oceans? Farm communities adopting laws recognizing the legal rights of pollinators? What would it look like if climate change activists began passing laws recognizing not only our right to a livable climate, but the right of the planet itself to a healthy, unpolluted climate system. What would it look like if we stopped listening to those who say we can't, and we began instead to drive the rights of nature into local, state, and national laws and constitutions around the world, as we've worked on with our partners over this past year, with state legislation introduced into the parliament in Western Australia, national legislation introduced into the Filipino Congress, and a national constitutional amendment introduced into the Swedish parliament.
Change doesn't happen just because we want it to, or even because it needs to. Change happens when you, me, all of us are willing to stand together to demand change. From the rights of ecosystems in Ecuador and the rights of rivers in Florida, to the call for the rights of the Himalaya in Nepal and the rights of the Great Barrier Reef in Australia, a new people's movement is building for nature. For this movement to blossom, it needs you. It needs you in your city, your town, your village, your county, your province, state, or country to become law drafters and law adopters, just like the people of Tamaqua, of Orange County, of the Philippines, of Ecuador, Australia, Nepal. You don't have to be an expert or a lawyer or a legislator. You just have to be someone who refuses to accept what is and instead works toward what needs to be. That's what movements are made of. People joining together to make fundamental change. As author Derrick Jensen put it, if we wish to stop the atrocities, we need merely to step away from the isolation. There is a whole world waiting for us, ready to welcome us home. Thank you.